Be ready? Start. On the other hand, the respondent filed a counter affidavit stating therein that in a writ petition filed by one Avanish Kumar, this court has directed that the respondent may inquire into the matter regarding the employees who have obtained the appointment under the dying in harness rules on the ground that their father or mother were in service of the respondent and died in harness, and on that basis some inquiry was conducted and it was found that the birth certificate submitted by the petitioner appears to be forget stop. Further allegation has been made that after inquiry, it was found that only to get an appointment in the police department, the forged certificate of birth has been submitted by the petitioner. Therefore, the appointment selection of the petitioner is hereby cancelled. Stop stanza. I have considered the submissions made on behalf of the parties and perused the record. Stop. From the averments made by the parties in the writ petition as well as in the counter affidavit, it does not transpire that petitioner was ever given a notice and opportunity before passing the order impugned. Stop. Admittedly, the petitioner's appointment was of 1989. Stop. In case some inquiry as submitted by the respondent was made and a conclusion was arrived upon that petitioner only to get an appointment has filed a forged certificate claiming that his date of birth is 15/11/1969. Stop. Petitioner's case is that he has passed the high school in the year 1983 and certificate issued by the board was submitted mentioning therein that the date of birth of the petitioner is 15th November 1969. Stop. The respondents have not disclosed the fact that from where they have inquired into the matter and what are the documents to show thereunder that the certificate submitted by the petitioner was forged. Stop. Therefore, in my opinion, it was incumbent on the part of the respondents to have a proceeding against the petitioner as provided under the rules. Stop. The regulation itself provides that in case of some misconduct or if on the basis of some inquiry it has been found that a person has obtained the appointment by playing fraud, in that circumstance, unless and until the procedure of inquiry as provided under the rules is followed, no disciplinary action can be taken against an employee. Stop. It is also not the case of the respondent that after verification from the petitioner also it was established that the appointment has been obtained by playing fraud. Stop. Therefore, in view of settled principle of law, it was not necessary to give a notice and opportunity and to have a disciplinary proceeding against the petitioner, as it is settled in law that fraud vitiates everything unless and until it is established the procedure as provided cannot be bypassed. Stop. Article 311 within bracket 2 of the Constitution of India provides for dispensation of inquiry in case a finding is recorded by the disciplinary authority that it is not possible and feasible to have an inquiry in the circumstances of the case. Stop stanza. This court has taken a view in the similar fact and circumstances that in case at the time of appointment a caste certificate has been filed and subsequently it was found that the petitioner does not belong to said caste, in that circumstances without holding a full-fledged inquiry the appointment selection of a person cannot be cancelled. Stop. In view of the matter, the alleged act or conduct of the petitioner was of at the time of his appointment while entering into services. Therefore, the same would not constitute misconduct during the service, as such order of dismissal for alleged misconduct could not be passed against him. Stop. In my opinion, this submission made by the learned counsel for the petitioner have got substance and deserves to be accepted. Stop. I am of the considered view that the alleged conduct of the petitioner while entering into service cannot be alleged to be misconduct during service. Stop. In service law jurisprudence, both the stages are quite distinct and distinguishable. Therefore, they should not be intermixed, otherwise, it will cause serious repercussion in the service law jurisprudence. Stop. Stanza. The trial court, on the basis of medical evidence, held that death of Seema was homicidal. Stop. As to the culpability of the accused for an offence under section 302, the court held that in the light of the evidence of father and mother of deceased Seema, it was clearly established that the appellant mother-in-law of the deceased was harassing Seema. Stop. The trial court also observed that it was true that in the first dying declaration the deceased did not involve her mother-in-law, but it was because of the fact that she was asked by her mother-in-law not to implicate any member of the family of the appellant. Stop. The trial court noted that after the first dying declaration was recorded, the parents and inmates of deceased Seema had reached the hospital. Stop. The deceased could get courage to state true facts, and again the special judicial magistrate was called and the second dying declaration was recorded in which she disclosed true and correct facts. Stop. Stanza. The trial court also noted that the special judicial magistrate was conscious of the fact that in the first dying declaration she had not involved any family members of her in-laws. Stop. A special question was therefore put by him as to the reason why she had done so, and the deceased had replied that it was because of her mother-in-law who asked the deceased to do so. Stop. The trial court therefore held the conduct of deceased Seema as natural and the second dying declaration reliable, which could be treated as a basis for holding the appellant guilty. Stop. The trial court also observed that from the evidence of PW2, father of the deceased, and PW3, father of the deceased, it was proved that Seema was ill-treated by her in-laws and particularly the appellant mother-in-law. Stop. The court also observed that PW5 had no axe to grind against the appellant. Stop. PW5 stated that on being questioned, Seema stated that she was burned by her mother-in-law by throwing burning kerosene lamp on her, but she had not stated so in the previous dying declaration because of the insistence of her mother-in-law. Stop. On the basis of evidence of parents of deceased. Stop. The trial court convicted the appellant. The learned counsel for the appellant contended that both the courts have committed an error of law in replying upon the second dying declaration. Stop. It was contended that the first dying declaration was correct and the deceased had stated true facts in the said declaration. Stop. It was also stated that after parents of the deceased had come to the hospital, they had persuaded the deceased to involve and implicate the appellant, and that is how the second dying declaration was recorded, which could not have been relied upon and no motive was established by the prosecution. Stop. It was therefore submitted that the appeal deserves to be allowed by setting aside the order passed by the trial court and confirmed by the High Court. Stop. Stanza. The public prosecutor for the state, on the other hand, supported the order of conviction and sentence passed by the trial court and confirmed by the High Court. Stop. He submitted that the conduct of stop over.